All right. All right. The next case in today's docket is the court case number 0135. Let me locate that.
Hey, Judge.
Yes.
I'm gonna get out of here, sir.
All right. You have a good one.
Here's woman.
Thank
If
you.
you need me, call me.
Will do. Very well. So we have Atticus Finch versus BCSO. All right. Beginning with the plaintiff, followed by the defendant. If I can please have plaintiff first, state full name for the record. Hello.
Stand by.
What's what is going on?
Yeah, stand by, Your Honor.
Okay.
How's it going, dude? Do you have a pending case? What's up?
Okay. Opening statement. So
Do you have a pending case?
the state's position is they want evidentiary hearing, basically, to find negligence sufficient to warrant restitution to the estate. In any civil negligence matter, there's four simple elements: duty, breach, causation, and harm, and all four are present here.
Doesn't matter.
I've lost.
Uh,
There we go.
Yes, I am.
the officer had a duty to act, regardless if it was BCSO, a state ranger, or somebody just in the detention center. Every officer has a duty to act. Second, there was a breach. My client was making multiple statements about seeing stars or fading to black. These are standard terms that are used when somebody needs additional help, medical.
How's it going?
Hello, there was a thing I've been called for jury duty.
Go ahead and walk through slowly.
Third was causation. Had somebody taken some action, there was a higher probability that my client would have survived. And then fourth, harm. Death is the ultimate harm, and this is wrongful death in this case. So the state is prepared to proceed with an evidentiary report and show cause hearing, and defers to the court whether additional action or trial is necessary. Our goal is a fair determination based on the facts in front of the court. Thank you, Your Honor.
Thank you for providing the court an opening statement. The opportunity will be given likewise to opposing party. BCSO, do you have an opening statement you'd like to offer, or are you waiving?
Yes,
Okay.
Your Honor, we do. For the record, my name is Ryan Barnacles with the Blaine County Sheriff's Office legal team. I'll be representing Under Sheriff Barnes. The defense respectfully moves for dismissal. Plaintiff's own evidence, specifically the unified timeline, conclusively defeats the legal elements required for the lawsuit that they're filing. The agency that observed medical distress was NCIS. BCSO was never. There was no communication with the Blaine County Sheriff's Office under sheriff that there was medical distress. There's no way to establish opportunity since the detainee was seen collapsing at 8:26 and 14 seconds. So 14 seconds after being placed in the holding cell.
Sir, can you stop reaching in your pocket?
No reasonable officer, especially under Sheriff Barnes, somebody with basic life support training, could not foresee, diagnose, or respond to a sudden collapse in the time frame. There's no breach as well, since Under Sheriff Barnes was not present at the moment of the collapse, and as we can see in the exhibit being shown. Your Honor, as soon as the detainee collapsed, there was medical attention provided to the best of the extent, and there's no way to establish causation since the detainee flatlined within approximately 1 minute of collapse. The plaintiff would need to provide an expert testimony and medical theory that would establish that an intervention in 14 seconds would have made the difference between flatline and the detainee being alive. The defense would like to state that
You're a jury.
tragedy alone does not create constitutional liability. We respectfully request dismissal with prejudice.
Thank you for providing your opening statement.
Sir, you have a jury.
Um,
Okay.
No.
Disregard. Sorry, I was unaware.
this is not a jury
Put the bat
trial.
down. Put the bat down.
Says bro.
All right. So now that opening statements have been offered, the burden of proof falls upon the shoulders of the plaintiff to prove beyond a reasonable doubt that all claims made are supported by evidence. Please do show cause. The floor is yours.
Okay, Your Honor.
One more prop from you, or anything that you're gonna be removed from the courthouse.
The defense is continuing to rely on the indifferent standards applicable to federal constitutional claims under 42 U.S. Code 1983, subsection 1983. But this matter isn't a federal civil rights action. It's a simple negligence case. Duty, breach, causation, and harm. All four were met. Duty was attached to the second BCO accepted custody. Breach occurred during verbal medical complaints that were ignored, not just to NCIS, but also to BCSO when he was taking the my client into the jail. When my client was placed into a cell still restrained, this caused additional stress to my client,
You just go fucking.
or
bitch.
it's perceived that it caused additional stress to the client and could have further exacerbated his state.
Don't use profanity, please.
Causation is civil negligence. It's not the substantial factor test, which has been done here without medical certainty, of course. Medical records do not show any outstanding health issues for my client.
Oh, how'd you know? Yeah.
It's just a standard medical exam, but the doctor says that the situation that the client was placed under may have led to the situation that came about. BCSO was not aware of my client's medical condition upon transfer from NCIS. However, that does not absolve him of liability for my client.
Do you rest at this time?
No, sir, just a second.
Oh, sure.
Do you guys have pending cases? Do you guys have any pending cases?
So the defense's argument applies to the wrong legal framework and should not control the outcome of this case.
Sir, in the flannel shirt,
I return the floor.
do you have any pending cases?
Right. The court will note no objections
How's it going, man?
How's it going?
from opposing.
No, I do not.
All right.
And the floor is yours.
Your Honor, the plaintiff continues to make a fundamental error in legal theory, whether this case is under U.S. Title 43, Section 1983, or under the state civil negligence. The elements of liability are still the same: knowledge, breach, and causation. First off, the plaintiff argues that subsection 1983,
How's it going, sir?
that it's not a subsection 1983 case, which is not material to the case in question. Under civil
Never mind.
negligence law, a defendant still cannot be liable without knowledge of a medical risk and an opportunity to act. The unified timeline in Exhibit A shows that NCIS observed all the signs of medical distress, but the Under Sheriff Barnes was never informed. In second place,
Objection, Your Honor.
What is the basis?
I'm calling for speculation on BCSO officers' actions at the time.
Sustained. Proceed.
Well, secondly, plaintiff claims that breach occurred the moment that NCIS handed the detainee to the Blaine County Sheriff's Office, which is legally incorrect. A breach requires a foreseeable risk, and a sudden collapse within approximately 14 seconds of custody is not foreseeable. Therefore, BCSO cannot breach a duty regarding a risk that was not made clear by the transporting officer who assumed custody at the scene.
Who transported
Uh,
the deceased?
Sorry?
Who transported the deceased?
Two NCIS officers.
Not BCSO.
BCSO was handed custody at the station.
At the station. Okay. Very well.
The plaintiff. Thirdly, the plaintiff states that the lack of knowledge does not absolve the Blaine County Sheriff's Office, and respectfully, lack of knowledge absolutely does absolve Under Sheriff Barnes under any civil negligence standard. A defendant cannot breach a duty regarding a risk they could not possibly know about. There was no communication from the defendant to Under Sheriff Barnes that he was feeling unwell, besides his obvious collapse whenever he was inside the cell. There's no legal basis to impose liability for a hidden condition that another agency failed to disclose. Fourth, the plaintiff argues that causation does not require medical certainty, which is true, but because causation still requires a plausible causal chain. The detainee was on the floor within seconds and flatlined within about 1 minute. There's no evidence or expert testimony that has been offered to show that any action by the Blaine County Sheriff's Office under sheriff could have changed the outcome. Plaintiff has produced no witness, no testimony from NCIS, no testimony from SSR, no expert medical evidence, and no causal theory that fits the timeline they provided. Even taking every fact in Exhibit A as true, the estate still fails to establish knowledge, breach, or causation, which is insufficient under subsection 1983 and equally insufficient under state negligence law. We therefore renew our request for dismissal with prejudice.
Thank you. The court notes
The
again.
defense rests.
Thank you. The court will note only one objection made and a ruling of sustained being made. Any rebuttals to the claims being made, plaintiff?
Yes, sir. So, if the estate's not going to dispute that the 42 U.S. Code, subsection 1983, can apply to cases involving detainee medical needs. However, the estate is not limited to a single cause of action. This case properly includes both a state-level wrongful death negligence claim and a subsection 1983 claim, per the defense, arising from the right to necessary medical care while in custody. That is the foundation for the defense's claim to remove this case. So even if applying the heightened subsection 1983 difference in different standard, the record still supports proceeding. Under subsection deliberate indifference, the plaintiff must show the detainee faced a serious medical need. The officer knew of and disregarded an excessive risk to the detainee's health, and the failure to act caused harm. All three of these are present here. Mr. Maleo repeatedly stated he was seeing stars and fading to black while in BCSO's custody. He showed visible instability during transfer through his collapse inside the cell. Deputies and rangers in the booking area heard or witnessed the symptoms. He collapsed within seconds of placement into his cell. No immediate action was taken by the rangers standing feet away. The subject remained restrained while he lost consciousness, and BCSO conducted no medical inquiry upon accepting custody. However, it is noted that they did attempt medical care after the fact. These facts all meet the subsection 1983 deliberate indifference standard under Estelle versus Gamble and Farmers versus Brennan. If the court applies the 1983 ruling, the state's claim still survives. Either standard supports restitution to the estate through negligence. Thank you, Your Honor.
Step forward.
Thank you.
Come through.
Any rebuttals?
Alright. Face the wall.
Your Honor, the fact that NCIS failed to warn BCSO specifically says and states that the defendant knew of a risk and failed to act reasonably.
Excuse
If
me.
NCIS
Excuse me, just a second. Just a second. Can we have that individual escorted out? Proceed. Sorry.
as I was saying, if NCIS hid the risk, then BCSO could not possibly be in breach. This is the exact same reasoning that we use for jail transfers, prison to hospital transfers, interagency transports, EMS hands off, and state to county custody transfers. If as long as the undersheriff had no knowledge, there can be no liability assessed to Undersheriff Barnes. The plaintiff is attempting to shift
I'm pretty sure this guy
CIS's breach onto BCSO, but the law does not allow for that. Liability is based on what the defendant actually knew or reasonably should have known at the time.
So here's my question then, to gain further clarity as to the statements that are being made and how these statements will eventually impact the outcome. Excuse me. Just to get this all the terms correctly, the initial detention was made by which branch or which law enforcement branch?
Based on video footage that was obtained from body cams, NCIS was the transporting agency. I do not know if they were the arresting agency. They transported over to the trooper station and turned over
Excuse me, are you the judge?
Mr. Maleo to BCSO
Hello?
in the parking lot.
Are you
It
the
is
judge?
unsure if this was a communicated handoff
judge,
or
I
if
can't
this
hear
was
you,
just a
man.
random drop off at the station.
Yo, are you the judge?
Okay, so then that would translate to, again, the question being, if NCIS was the agency that was delegated transportation of the now deceased individual,
Just say, trust me, it'll get better.
then who made the initial arrest?
Actually, I'm gonna take seriously. Yo, sir, I have a question. I might.
There's no sworn
okay,
affidavit.
there's-
There's no statements.
Okay.
There's
Is that
no body
possible?
cam evidence.
Okay.
It's something I cannot comment on.
So,
I am.
understand. So
And
go ahead.
I would
sorry,
take
Your Honor.
seriously
Additionally, I do not have that
Fast and
information
Furious
either,
103.
but if not mistaken, California Penal Code requires federal agencies to contact
I heard
local
he
law
lied.
enforcement for transport and booking
Oh,
of
no, I heard
prisoners,
he's part of the
which
okay.
NCIS did
Okay.
perform by transporting the prisoner themselves and turning them over to BCSO. Once in BCSO's custody, they have full accountability for the prisoner's actions, regardless of information that was passed off from a federal agency or not. They're, the descendant, made a comment twice that he was seeing stars in fading black to BCSO moments within being removed from NCIS's vehicle.
Would you
And any reasonable offer would understand that they're asking for assistance in or they're in medical distress.
kindly?
Objection.
What is the basis?
Are you asking for grounds? The objection is based on misstatement of law and improper argument.
How so?
Negligence requires actual or constructive knowledge. NCIS's failure to warn cannot, as a matter of law, be attributed to BCSO. The plaintiff is arguing a duty that does not exist.
Any rebuttals before a ruling is made on that objection?
Yes, any individual who is incarcerated or in police custody, whether it be an adult or a juvenile, becomes a individual under state care and custody,
This is correct.
regardless of the agency or location, whether it's a local jail or a correctional facility,
Right.
there still is a duty to provide care. If my client did not make any comments or statements regarding his health concerns, I would understand that BCSO would not have prior knowledge of this. However, the client did make 2 statements on his way down to the cell, to the booking area, before he passed out. This gave the the booking officer knowledge that there was an issue going on through the statement "seeing stars" and "fading to black," which is on body cam and has been entered both audibly, visually, and through transcripts. If a detainee is visibly unstable, previously complained during transport, which he did do, but NCIS failed to relay that information to BCSO. My client did make statements to BCSO as well upon arrival, so that shows that he continued to make statements regarding his health concerns. So this doesn't absolve BCSO or NCIS or any other agency of liability. This actually increases their liability because now they have a duty to provide care for any individual in their custody. And the fact that my client was also still handcuffed means that my client could not assist himself and required assistance from a law enforcement or medical personnel. That's all. I got.
Objection.
Hold on, because okay, what is the basis of that objection? Oh my God!
You talking to the plaintiff or the defendant?
No,
Your Honor?
you've made an
There's
objection.
Yes. The plaintiff is calling for speculation.
What the fuck?
Where is the speculation happening from?
We do not know if the deceased being restrained or not could have possibly helped him at the time or not. The only evidence seen in the body cam footage provided is the defendant providing medical whenever he saw the deceased collapsed inside the cell.
Apart from that, the validity of the response that was being given prior to the objection remains valid. And I'll explain why. Regardless of whoever was performing transport, their duty is primarily just that, to transport. If there is no apparent need for healthcare services prior to the process of getting the individual situated within the facility, the responsibility, because we know that during transport, you don't have the ability nor the required elements other than to transport, right? Once arrival at the facility where the person is to be processed, the law does require that if there's any evident or suggestive, even suggestive medical needs that are unmet, there is a contracted provider, whether it be a physician, registered nurse, nurse practitioner, physician assistant, or an advanced practice nurse, to evaluate and ensure
Talking to yourself in here, man.
and ensure that there is nothing happening medically with the person in their custody. So leave the premise.
Hey, you do know that like there was just a massacre in your courtroom.
I
right?
have a court hearing taking place. You have to leave this
How
area.
do you- there's a court. Everybody in your courtroom is dead, man.
Third time, please leave the area.
Well, so
I'm placing you in handcuffs.
oh hell no. Hell no, this is illegal as all fucking hell. I'm trying to report to you about a massacre. This is illegal. You're gonna go on report unless you let me go. I am trying to report it properly.
Does
You
it
need to
look
let me
like
go.
does it look like a
False arrest.
judge that
Now,
is
this is a false
unable
arrest.
to
I was
wield a
telling you,
firearm?
I'm trying to let you know that there was just a massacre in your fucking courtroom and you put me in handcuffs.
And I heard you multiple times. There's nothing I can do about that. I'm not law enforcement.
Yeah. Then if you're not law enforcement, then you need to fucking let me go right now, or else you're gonna get reported.
You
This
can
is
perform
bullshit.
your report. That's not
Oh,
an
I will
issue.
perform my fucking report. This is ridiculous. Everybody in here just got killed, and you're not doing nothing.
There's nothing I can do. All right. 1 foot and 2 foot. There you go.
You need to take these off me, man.
Let's go ahead and exit the premise.
Dude, get the fucking handcuffs off me. You have no legal authority to be doing this bullshit.
That's where you're wrong.
No, I'm not wrong. You are not an officer. You're a fucking judge. You don't get to handcuff
Correct.
people.
Oh, I
You
certainly
need to call
can
fucking
handcuff.
cops. And I was
Hmm.
reporting to you about a fucking murder, and you don't give a shit. So you need to get these fucking cuffs off me now.
Sir, I can take him from here. If
Thank
you
you.
want to.
Please do.
Yeah. And I'll take him to the station.
Thank you. Please pardon the interruption. Like I was saying, there is an implied anytime anyone is taken into custody, that person is completely under your care. Anything that happens to them, well, they are in your custody. They can't do anything for themselves. They require you to provide anything that they need, right? So although I do find partially reason on your end, I unfortunately do have to overrule and continue on. Mr. Atticus.
Yes, sir. Your Honor, I mean, that's precisely the state's position. Whether, and any agency who accepts custody of an individual, a duty of care is implied and active. So the state's argument is simply one that duty existed. Several reasonable steps were expected as part of that duty that were not taken. And asking about medical complaints during transfer, observing visible instability, responding when the descendant reported seeing stars and fading to black, all intertwining prior to the collapse in the holding area. So the duty is not disputed. The estate fully agrees that taking someone into custody carries an implied responsibility for their well-being. The question before the court is whether the duty was met under other circumstances. I'm sorry, under the circumstances in my filing. Sorry, headache, just a second. So I'd like to follow up with that as well. We're not stating that BCSO or any other agency is at fault. This is a failure within the system itself.
Right.
Unfortunately, BCSO was the agency that placed the individual in detention, so the responsibility fell on them and the detention center itself, which was a standard trooper station. So, like as I'm starting to state, this is not BCSO officers' direct responsibility. This is a failure within the system to recognize individuals' requests for medical assistance and then failure to provide that care when repeatedly requested. Thank you, Your Honor.
Oh yeah, because this is
Okay.
so cool, man.
We are going to move for closing statement right after. I mean, if you have anything further to add,
Motherfucker, you don't even know about the law.
Mr. BCSO legal team.
The defense does. Your Honor, as we've stated before, and as the plaintiff has quoted Farmer v. Brennan, the Supreme Court has held that liability requires actual knowledge of a substantial risk. In Farmer v. Brennan, the Supreme Court held that an officer is only liable if he knows of and disregards an excessive risk to inmate health or safety. Without actual knowledge, there is no constitutional liability. In Kingsley v. Hendrickson, the case reaffirms that knowledge and foreseeability are required in custodial liability analysis. So again, BCSO had no awareness, and BCSI did. BCSI and NCIS did. In Grayson v. Pede, officers are not liable for sudden medical absent warning signs. Officials are not liable for a sudden or unforeseen medical emergency. And again, negligence requires knowledge. There's no strict liability. Daniels v. Williams, holding Section 1983 of Title 42, liability does not apply to mere negligence or accidents. The Constitution does not impose liability for lack of due care. So there's no reason BCSO should have known at this time. NCIS actions were a single incident, therefore BCSO is not liable. In Your Honor, under Title 14, Section 14.32, the transferring agency, in this case NCIS, is legally required to disclose all known or observed medical conditions before a detainee is accepted into another agency's custody. Exhibit A shows NCIS observed the detainee's medical distress beginning at 8:24 and failed to disclose it. Under Title 14, this failure to warn keeps liability within NCIS. BCSO could not be held liable for medical information that NCIS was statutorily obligated to disclose and chose not to. Title 14 makes it explicitly clear.
Objection, Your Honor, as well. And mistakes the evidence.
Arrest what man?
I'm going to sustain that.
On what grounds? On what grounds?
BCSO was fully aware of my client's condition. My client had mentioned it to him twice immediately after removing him from the vehicle and bringing him in through the main entry door of the facility. So BCSO was aware of my client's medical condition upon reception, regardless if NCIS relayed that information or not.
Well, hold on just a second. What do you mean with medical condition?
Just what my client was stating when he was being taken out of the vehicle, that he was fading to black and seeing stars. Those comments were the two comments that he made after being removed from the cruiser from NCIS and upon entry into the building, heading down into the holding area.
Okay.
Those comments were made directly to BCSO officer.
Okay. Very well. Are you denying that? Defense?
No, defense was stating that BCSO had no knowledge. The information was not transferred over to him, to BCSO from NCIS. That's where I had made my objection on mistakes, the evidence. BCSO officer was clearly informed that there was a medical condition from my client on his way into the building, potentially passing out through seeing stars or fading to black. This was very clear in the audio, very clear on the body cam footage. So it wasn't something that was heard by a third party or possibly heard by another person in another room. This was a direct communication between my client and BCSO.
Right. That's why it is sustained.
Thank you, sir.
Now, is there anything further that anyone else would like to add as it pertains to this matter? Very well.
No, Your Honor.
Okay. We can now safely move to closing arguments, or you can choose to waive if you so prefer.
Defense would like to place a closing argument I'm sorry, the plaintiffs would like to place a closing argument. The defense would like some time to prepare.
Defense?
The defense is ready for closing arguments if plaintiff is.
Okay. Whoever wishes to go first, you may.
Plaintiff, on behalf of the estate, Your Honor, the defendant in this case did not die in the street. He did not die fleeing. He did not die fighting. He died in a cell minutes after telling multiple officers that he was losing consciousness. And no one asked a question. No one checked. No one called for help. Not until it was too late. The duty of care exists precisely for moments like these, for moments when a person's life is entirely in the hands of the agencies holding them, for moments when a person cannot help themselves. The state is not asking the court to assign blame out of anger. It is asking the court to recognize that a life was lost under preventable circumstances and that the duty owed to this detainee was not met. We ask for restitution to be granted and placed into the state's trust so that the family may find some small measure of closure. Thank you, Your Honor.
Thank you. Defense.
Your Honor, the unified timeline shows that whatever concerns NCIS gave BCSO were general and non-emergent in nature. Foreseeability requires that the information provided be sufficient to alert a reasonable officer to an imminent and serious medical danger. The detainee fell to the ground approximately 14 seconds after being placed into the holding cell. Even with knowledge that he was unwell or symptomatic, this timeline shows there is no reasonable opportunity for intervention before the emergency unfolded. The law does not impose strict liability for every medical complaint. Under both negligence principles and Farmer v. Brennan, liability attaches only where an officer has knowledge of a substantial risk or serious harm and the time and means to act upon it. A collapse in under 15 seconds eliminates the practical ability to intervene and defeats causation as a matter of law. Furthermore, the undisputed record shows that as soon as Under Sheriff Barnes became aware of the collapse, he immediately returned to the cell, conducted a medical assessment, attempted life-saving measures, including CPR, hooked up an AED monitor, and these actions are entirely inconsistent with negligence and defeat any suggestion that BCSO disregarded a known risk. Even assuming knowledge, the plaintiff cannot establish breach because there was no reasonable medical response available in the seconds between intake and collapse. The plaintiff cannot establish causation because there is no evidence, expert testimony, or factual theory has been offered showing that a different course of action by BCSO could have altered the outcome given the speed and the severity of the medical event. Your Honor, this case fails not because BCSO had no knowledge, but because even taking knowledge as given, the plaintiff cannot prove foreseeability of collapse, cannot prove breach of duty, and cannot prove that any action by Under Sheriff Barnes could have changed the tragic outcome. For those reasons, we move for dismissal with prejudice, and we stand that this is the appropriate and legally required remedy.
Thank you for offering a closing statement. The court requires 2 minutes for deliberation. Please stand by. Okay. All right. The court has heard this claim in its entirety. The court had ample time to examine and review all submissions of exhibit. The court has analyzed the mitigating circumstances. The court has analyzed and examined all presentation of exhibit. and it has reached a verdict. Now, before this verdict is issued, and the rationale that follows, I'd like to inform both parties that I understand the functions of counsel can be quite difficult at times, very strenuous, and dedication is something that, at the end of the day, along with legal creativity, propels you forward, and that passion to prove your points is also a great motivator. However, a life has been lost. Could have been prevented? That is not something that I determine. But what I have with the following rationale: this particular case and the circumstances surrounding it does lack a certain measure of evidential and material proof to sustain the expansive action of the court. Nonetheless, there has been evidence presented, and therefore the rationale that follows is solely concerned with the presentation of that evidence. In the matter of Jack Smith, I'm sorry, not Jack Smith, that's crazy. That was a previous case, my bad. Would you tell me the deceased name again? Sorry.
The deceased was Brody Maleo.
There we go.
Case number 0135, sir.
Right. Brody Maleo. The matter of 0135, Brody Maleo, through his attorney of record, versus BCSO under sheriff. We lack a very important aspect, which was a medical examination, expert testimony, in order to prove whether a breach of duty, although partially met, I think that we're missing that component, and it meets end to justify a great deal thankfully, through the evidence. Did BCSO officers have enough time to respond? And if so, could any employed measures could have turned the outcome to an opposite one? That I don't know. But what I do know is that a life has been lost. And although I will say that, please note there's a difference, a big difference between negligence and ignorance. What exactly is the plaintiff seeking in terms of restitution?
Just a second.
Sure.
The plaintiff is seeking $950,000 in compensation for the wrongful death of Brody Maleo, scaled to the approximate valuation for current U.S. dollars, in regards to the preventable death in a Los Santos jurisdiction.
Okay. I believe that there is some sort of duty also here that wasn't performed by NCIS, but that is outside of my scope right now. Is this death wrongful in nature? We lack the expert witness testimony of a physician or a medical examiner to determine. But the court will rule today in favor of the plaintiff. But bearing in mind that the component of beyond a reasonable doubt has not been met at 100%, nonetheless, the court is inclined to favor the outcome for the plaintiff because notice was given, and yes, BCSO duly performed the care that they were trained to perform. However, would that care would have been sufficient or insufficient? Well, to be honest, since the component of negligence is to some extent a permissible act that can be claimed as a civilian when you're trying to help, the Good Samaritan law exists for a reason, but this was not a civilian. This was law enforcement. Case law that was brought into this matter was also examined, particularly the case law regarding the Supreme Court's determination. That particular case law was also examined, and this court orders the following. The court has and will, through its jurisdiction and through this order, require the Blaine County Sheriff's Department to issue, in the form of restitution to government state funds accounts, a total of $750,000 to be paid immediately without delay or hesitation. No action to be necessarily taken against any of the officers involved, as this is merely a systemic issue, not negligence directly through the officers. The court witnessed that every act the officer performed within reasonable time measures, but unfortunately, this is a higher issue concerning systemic functional systems. This is the order of the court. Thank you for your time, gentlemen. This case is closed and court is adjourned.
Thank you, Your Honor.
Thank you.
Your Honor, the defense reserves the right to file post-judgment motions or an appeal. We respectfully request the opportunity to review the court's written findings
Absolutely.
in the coming week.
That's perfectly fine. You have up to 30 days to file an appeal.
We are entering our notice of appeal.
That's perfectly fine. Thank you for your time. Hello. The court has heard oral argument, presentment of exhibits,